Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. You may have heard that a common goal of estate planning is to help your loved ones avoid probate. But why? What really is probate and why is everyone trying to avoid it? Learn more on today's webinar with attorney Bob Mannor. Before I pass the mic to Bob, I'd like to cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation, please contact us after the webinar. Also, if you have a general question during today's presentation, we encourage you to use the chat box. We will save time to review questions during the webinar. If for some reason we don't get to your question, we will contact you after the presentation. Also note that today's presentation will be recorded and the replay will be sent tomorrow so that you can share it with your family, your friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? We are nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Our managing attorney, Bob Mannor, is nationally board certified as an elder law attorney by the National Elder Law Foundation. In fact, he's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Hi, folks. So we're going to get right into this and just kind of stick to the basics here. And you should be able to see a slide here that kind of goes through the difference with probate avoidance and non-probate avoidance. And so on the top, the green arrows is going to show what it looks like in the event that there is probate avoidance. And one of the things we always like to point out and make people understand is that there's still a process that we want, that it's important to have your family go through after you pass, and you'll see that the process is a lot faster and more efficient and easier on the family and provides a lot of protections for the family. And we're going to talk about why it's important to go through that process for their benefit, for their protection, okay? And so a lot of people just think, oh, when you die, you go to the attorney's office, or you don't even go to an attorney's office, you sign over some deed, you split up the money, you split up the stuff in the house, and then we're done. Well, if you do that, you're exposing the person you put in charge, the executor or the successor trustee or the personal representative, you're exposing them to continuing liability. But if we do it right, if we follow the rules, then we cut off their liability. We make sure that they're not exposed to liability. Liability from people arguing about it, family arguing about it, spouses arguing about it, grandkids arguing about it, and legally having a basis for it, or creditors. Now, some of you would say, well, my family won't argue and I don't have any real creditors. Doesn't matter because that's the way it is now. What is it going to be later? What is it going to be after you die? Is it possible that you might have some grandkids or spouses of children or anybody else that might start to be greedy once they see some dollar signs that are there? Well, we want to make sure that we don't expose the person that you put in charge them to ongoing continuing liability. And the idea is if we do it right, we can limit that liability and really limit it completely if we follow all the rules. But the maximum time period where there was any exposure at all would be 4 months, as opposed to 6 years. If we don't follow the rules, it's 6 years. People can come back for 6 years and complain about the distribution. Creditors or fake creditors could come forward within 6 years and argue about whether or not they should have been paid or not. And I say fake creditors. So you might say, well, we don't owe anything to anybody. We don't have a lot of debts. Doesn't matter. There's still a process for them to be heard. I had a case several years ago where a gentleman, his spouse died. He was living alone for a while, and he made a friend next door. Friend was a little bit younger than him, and he'd come over, and they'd have a beer together. Usually, most afternoons, they would just kind of talk and chat, and he really enjoyed it. He enjoyed having that company of the neighbor coming over. And but there was, according to the family, there was no ever any discussion that he was providing care or that he was doing anything. He was just coming and visiting, like people do. And so then after the gentleman died, the neighbor filed a claim saying that he was told he was going to get paid. He was going to get paid $30 an hour for every hour that he came over and had a beer with his neighbor. And it seems like I'm exaggerating, but that's pretty much what the claim was. And then he had this scribbled piece of paper, who knows whose handwriting it was in or anything else, that he claimed was the agreement. And there was maybe 10 words on the piece of paper, and it was all wrinkled piece of paper. Well, he was able to file a claim on that, and we had to fight out that claim. Now, imagine that is 3 years after death, and the executor has to deal with that, as opposed to making sure that all claims go away within 4 months, and that if we follow the process, we can make sure those frivolous claims go away without any problem. Okay, so that's why it's important to follow a process, whether you avoid probate or not. So what this graph does is it shows you the process on the bottom half is what if we don't avoid probate. If we go through probate, we go through that process. So typically we look at about the first 3 months, 1 to 3 months, where we're getting information. We finally petition the court for authority. So sometimes people think, oh, if I have a will, we don't have to go through probate. Nope, if we have a will, we go through probate. The will is just instructions to the probate court. If we need the will to see where something's going to go, then we have to go through probate, the full-on probate, the full-on what's called decedent's estate. And the first step is to petition the court for authority. Okay, because the person that is your executor or personal representative in the will doesn't have any authority based on the will itself. They can't take the will to the bank. They don't have any authority based on the will itself. They have to get a petition from the court, and they have to get appointed as the agent or what they call personal representative under the court. We then have to serve interested parties. So who's an interested party? Well, it's your relatives. So what if you cut out a relative? What if you said, well, we haven't heard from Johnny in 10 years. We're not even sure where he lives anymore. Or maybe Johnny died and it's his kids. And so Johnny died and it's the grandkids now, because the grandkids stand in the shoes of Johnny, your son, if Johnny died. And so, but we lost track of some of the grandkids. They don't come by, they don't communicate. The last time you sent them a Christmas card, it got returned as that they didn't live there anymore. We have to send them notice because they're what we call interested people under the probate process. So we have to track down all the interested parties, send them a notice regardless of whether they're going to receive something or not. And that's a really important element here, because sometimes that causes trouble. Sometimes when you're sending a notice to somebody who's not getting anything, it's almost like kind of poking them in the eye and saying, you're not getting anything. And poking them in the eye might cause them to hire an attorney and cause trouble, right? And you don't have to do that when we avoid probate. We don't have to send notices to interested parties that aren't getting anything, that aren't actually a beneficiary of your trust if we do a trust. Next is the executor is assuming some liability here. So then we have a 1 to 5 month process where we're looking for whatever creditors there might be, known creditors, known debts, gathering the assets together, making sure we consolidate, that we put everything, that we get a tax ID number, we have a estate account, a probate estate account that the money is all consolidated in. We're dealing with real estate issues, making sure we secure the property, make sure there's insurance on the property, and notify the insurance company that the person died, making sure that we secure the car, secure the assets, make sure everything still has insurance on it, maybe change the locks, do all those types of things. Next 1 to 3 months is we have to file an inventory. Probate court requires us to file an inventory. So we file an inventory. Now they charge us. I look at the inventory fee as a tax. Why do I call the inventory fee a tax? Well, when they got rid of the estate tax or death tax in Michigan, they started this inventory fee, but it only applies to those things that go through probate. So if we stay out of probate, we don't pay this fee or tax. Why do I call it a tax? Because it's progressive. The more money we have, the more they're going to tax. So it starts out at about 0.5%. It goes up to 1.5%. The more money you have, the more percentage of the estate they're going to get as part of the fee. Okay, so a larger dollar amount, they're going to take a larger fee. Not just a larger fee, but a larger percentage of the fee, just like a tax, just like a progressive tax. We have to obviously send out all these notices to the interested parties, not just the heirs. It's us communicate with the heirs, but we have to send out all the notices to all of the interested parties. We have to send notices to known creditors. We have to publish notice for unknown creditors. We have to wait out that time period. Next 6 months to 2 years, we're resolving creditor claims. We file estate tax returns, which sometimes we can avoid doing if we don't have to go through this long process. We resolve any family disputes. And then once that's all over, then we wait another 30 days, file the final accounting, the final documents, and wait for objections. And if there's no objections, now we're ready to distribute the assets and do all of that. As opposed to if we avoid probate, this is what we're looking at. There's still a process, but we want that process now because it's there to protect your executor. It's there to protect your successor trustee. So gather the assets, pay the bills, liquidate the assets if necessary, or hold them if we're going to distribute them out in kind. We make sure that if there's any beneficiary notices that we can file the beneficiary forms. If there's any known creditor claims, we need to notify known creditors. We do set up a publication to make sure that it cancels any unknown creditors. We've seen research that says that this process saves about 500 to 800 hours of executive time. But from the person that you appoint, saves that much of their time. It provides protections for the heirs. So some of the planning that we do provides continuing protections from divorce and bankruptcy and things like that to your kids or grandkids to make sure that the money they get from you that they're able to use. Make sure we file our final tax returns. We do an initial partial distribution. We issue any trustee reports as far as the final accounting. We review any trust options if there's any specifics like specific bequests. We instruct the heirs on minimizing taxes. That's one of the very, very important things. So if you have any retirement accounts, the new law allows everybody to have a whole variety of options. So if they don't get proper advice, if they just say, okay, well, I'm a beneficiary on mom's IRA, give me the money, I'm done, probably going to mean that Uncle Sam gets about 40% of that money. It could have been set up so that Uncle Sam gets a very small percentage of that money, but if they don't do it right, then they're going to end up paying way more in taxes. And there's everybody's circumstances are going to be different. So a lot of times people want this magic pill. They want it to be, okay, one size fits all. There's 6 kids, each are going to get a 1/6 portion of my IRA. Well, each of the 6 kids might have different tax circumstances. And so they all need advice on this. That's something that we can provide to them to make sure that they're not going to pay more taxes than they have to on those retirement accounts, those IRAs, 401ks, qualified annuities, things like that. And the biggest thing on this is after 4 months, we can shut down liability for your executor so that they have if anything comes in after that period of time, if we follow this straightforward process, anything that comes after that period of time, we can just say, sorry, you're time barred. Have you ever heard the term statute of limitations? Statute of limitations means that they can't file a lawsuit anymore. They can't file a collection action anymore. They can't dispute the estate process if we followed that process. So if they don't follow this process, they could have up to 6 years. If they do follow this process, we can cut that off in about 4 months, okay? We do often recommend they hold back a small amount. So we distribute most of the assets. We recommend they hold back a small amount to make sure that there's nothing else that comes in, and that primarily the main purpose of this is because we can't file your final tax return until the following year, until the following January or February. And so, well, it's unlikely that you're going to pay any taxes. We don't want any surprises. We don't even know what the tax law is going to be next January or February. So I usually recommend that the executor, the successor trustee, would hold back a small amount. When it turns out, after we pay for the tax filing, And when it turns out there's nothing owed, then everybody gets another small distribution. But that's the process as opposed to the probate process. All right. So I always like to talk about the next thing here. So this is what the administrative process looks like. And we always try to say, you know, consider not doing this alone, that often you're going to actually save money by hiring us to help you through this administration process, particularly if it ends up having to go through probate. But the goal here is to stay out of probate, which was the process that we talked about. Oops, went the wrong direction, which is the process that we talked about at the bottom of the page down here, having to go through that court process. The second thing that is extremely important when we talk about avoiding having to go through probate is probate before you die. This is extremely important. I look at this as more important than if you had to go through probate after your death. Of course, most people would prefer this top section and having everything go much more smoothly and faster than having to go through this probate process. And so, but you're dead. And so the reason why I'm saying that is, worst case scenario, we're still going to make sure that things are going to get to where they're supposed to be for the most part. It's going to take longer, going to cost more money, and all those types of things. So what I consider our worst scenario is you're still alive and we need to go through probate. Why on earth would we have to go through probate if you're still alive? And the answer is, if we need somebody to make medical decisions for you, or more importantly, if we need somebody to make financial and legal decisions for you. So you say, well, can't we just do that with the financial power of attorney? Can't we just do that with the patient advocate? And the answer is yes, of course we want those. But particularly when it comes to financial assets, the trust is going to make it much more straightforward and more enforceable, so that the people you have appointed as your successor trustees, as the people that would help you in the event that you have Alzheimer's or dementia or a stroke or any of these things that could happen to us, have a more enforceable authority. We often send powers of attorney and the bank initially rejects it and sometimes give us the runaround. We've had a good amount of success getting the bank, getting the financial company to eventually, sometimes after jumping through tremendous hoops, eventually accept the powers of attorney. I have talked to plenty of other attorneys that just gave up. And the problem in Michigan is the power of attorney doesn't have any way to enforce it in court. We can't go to court to enforce it, where the trust does. If that asset is part of the trust, we can go to court and enforce it and force the bank and force the financial institution to follow the terms of the trust and follow the terms of the person you appointed as your successor trustee. Now, we've never had to do that. Why? Because we have the threat of it. Because we have the threat of saying, hey, if you don't do this, we're going to go to court and force you to do it, and you're going to pay our attorney fees for forcing us to, take you to court. We can't do that with a power of attorney. We can do that with a trust, which gives you more incentive to say, okay, well, I definitely don't want a judge making decisions for me while I'm still alive. I want the people I want to make those decisions. I don't want the judge appointing somebody to make decisions, right? And I don't want there to be this big family fight about it. And so the trust often is a much more effective method of making sure that you're going to stay out of court even during your lifetime, which I think is a much worse scenario, where now you have a judge involved in making decisions about where you're getting care, how much we're paying for that, how much money we spend. There's a lot of terrible cases out there recently that have made the news, and the Attorney General's office and the governor's office have done this elder abuse task force where they're trying to do a lot of guardianship reform, because there's been some pretty extreme ones, including there was one out of, I don't know which town it was, but it was out of the Oakland County, Detroit, Macomb area, Southeast Michigan, one of the areas down there. The family had requested to be appointed guardian for the parents. The judge decided they weren't going to appoint the family, they were going to appoint a guardianship company. That guardianship company then hired, with the owner of that, hired her husband to provide legal services, whatever that is, hired the owner of that guardianship company, hired another company that she owned that provided the care, and they end up spending $400,000 in a period of 6 months of these people's money. It shouldn't cost that much. It seemed a whole lot like self-dealing, where the person that the judge appointed, or the company that the judge appointed, the person that owned that company owned all these other companies, had a husband that was a lawyer, and spent all this money in a very short period of time, and excluded the family, kept the family from being able to visit the parents. Okay, this is a real case. It was in the news. This is what got the governor's attention and the attorney general's attention, that they're trying to reform this. But those are the types of things I say. We want to stay out of probate. Sure, it's important to stay out of probate after you die. It's even more important to stay out of probate while you're still alive. Okay. Now that's my perspective. Other lawyers will have a different perspective. That's my bias, if you want to call it that. Okay. But that's where I see is the value of staying out of court, the value of doing thorough, holistic, complete estate planning, is to make sure the court doesn't involve itself except under very, very limited circumstances. So that's the basic ideas here. And so if you have any questions, we are going to give you an opportunity to get your questions answered. A lot of times you might have individual questions about your individual circumstances. So we're going to give you an opportunity to have a free call with our office, or just to schedule an appointment, and we'll figure out what the next steps are. So if you want to just start off with just a quick call, we can do that. Or if you want to schedule a consultation, we can absolutely do that too. So Savannah, why don't you give them some instructions about what that process looks like?
Thanks, Bob, and thanks for everyone else for joining us today. As Bob mentioned, we do have some easy ways for you to get in touch with our team. If you notice in the chat, I have put our phone number in a link. Our phone number is 1-800-990-6030. Again, that's 1-800-990-6030. Or if you click the link that's in the chat, that will take you to a calendar. On the calendar, you will choose a day and a time where our team can call you. So maybe now's not a good time for you to pick up the phone, but once you leave the webinar, you'll forget to call us, or if you're like me, it'll be 3 in the morning and you wake up and go, oh, I need to call them. Well, you can just go ahead and schedule a time for us to give you a call when it's convenient. I also will be sending you an email probably in about 15, maybe 20 minutes. That email will also have our phone number and the link. And of course, the replay will be sent out to you tomorrow with another opportunity for you to get in touch with our team. Remember, there's no obligation to move forward. There's no risk with this call. It's just an informational opportunity for you to learn about us and for us to learn about you. So we hope to hear from you, 1-800-990-6030. And of course, we hope to see you again next week. Take care.